Greetings, my fellow Dream Love Sovereign Thinkers. It's LO3's News Podcast. My name is Craig, transmitting from the beautiful Smoky Mangroves of South Florida. And today's date, it is Thursday, July 5th, 2017. Forgot to put my mic up, mic down to my mouth. Well, hopefully everyone enjoyed their Independence Day in the United States, which is considered the Declaration of Defiance. And make sure you exercise your natural-born rights honorably. All these little laws they have on a local level that infringes on those basic rights is considered null and void. As long as you don't violate others, of course. Plus, I'm at CJ's Java Lounge, located at 400 Southwest 1st Avenue, Suite 1 to be exact, along the New River of Fort Lauderdale, Florida. Southwest section of the Andrews Avenue Bridge at the New River Yacht Club. Yeah, so I have a couple folks here, and new employee, cool little customer, just shooting the breeze. And I'm going to be mainly talking about Florida Stand Your Ground law, the new one, which is considered SB 128, self-defense immunity. And Judge Hirsch from Miami-Dade County ruled it unconstitutional. This came from the Miami Herald a couple of days ago. It says here, Miami judges rules Florida's new standing ground law is unconstitutional. And what I'm going to be doing is mainly focusing on this. And may see how long it takes. So I'm not going to try to go too ape or digress. So I will proceed. This is by David O'Valley. Florida's updated standing your ground self-defense law is unconstitutional. A Miami judge ruled on Monday. Miami-Dade Circuit Judge Milton Hirsch ruled that lawmakers overstepped their authority in modifying the law this year to force prosecutors to prove a defendant's self-defense claim at a pretrial hearing. The judge ruled that under Florida's constitution, that change should have been crafted by the Florida Supreme Court, not this legislator. He's talking about how the proceedings should be done, and I will explain that in here. As a matter of constitutional separation of powers, that procedure cannot be legislatively modified, Hirsch wrote in a 14-page order. The ruling is a victory for prosecutors who firmly oppose a law they believe makes it easier for defendants to get away with murder and other violent crime. Hirsch's ruling isn't binding. Other trial courts across Florida can follow the law if they choose. But it does get the ball rolling in the appeal process and possibly getting law reviewed by the Florida Supreme Court. Senator Bradley, Republican from Fleming Island, told the Miami Herald he believed the legislature acted lawfully. It would be surprising if this decision were upheld at the appeal level, said Bradley, a former prosecutor who championed the modification of the already controversial Stand Your Ground statute passed over a decade ago. The change was pushed by a politically powerful National Rifle Association. Rick Scott signed a new law into effect last month. That's mainly subsection 4 of the statute. First passed in 2005, Florida's controversial self-defense law has been criticized for fostering a shoot-first mentality and giving killers a pass at justice. The laws eliminate a citizen's duty to retreat before using deadly force to counter an apparent threat. More problematic for prosecutors, law made it easier for judges, before ever getting it to a jury, to dismiss criminal charges if they deem someone acted in self-defense. The Florida Supreme Court later ruled that defendants asking for immunity for criminal prosecution must be the ones to prove they were acting in self-defense. In Miami-Dade, judges have thrown high-profile murder cases after pre-trial immunity hearings, must have also allowed many more go to a jury. But the NRA-backed bill passed in May despite fierce opposition by prosecutors and gun control advocates upended the legal framework. What I can say is about prosecutors, a lot of them out there in the legal system. In Florida, for example, you got a lot of vampires out there. They just want to really manifest. Not all of them are for justice, but that's just not all, but a great amount. I'll be very fair on that. But I will continue on. Now, at those pretrial hearings, prosecutors shouldered the burden of disproving a defendant's self-defense claim. State attorneys contended that it essentially forces them to unfairly try the case twice, making it easy for criminals to stake on violent charges. Under the law, prosecutors must prove a clear and convincing evidence that a defendant was not acting in self-defense. So the whole thing is, they have to prove it, okay? And based on the original law, that the defendant or the petitioner that try to file for standing ground or self-defense have to prove it to them, which could be considered incriminating, under Article 1, Section 9 of the Florida Constitution. So I was going to proceed here. Hirsch found that the changes to the law were procedural, meaning only the Florida Supreme Court has a right to make them. So on a procedural basis. So I will, I'm going to explain all this little by little. Hirsch ruled on the case on Lather Rutherford, who was accused of aggravated assault for pulling a gun on a couple during an argument on Omar Rodriguez, the so-called neighbor from hell, who shot and killed a man after a confrontation over dog poop. The separate immunity hearings will still be held in the coming weeks, but it will be up to the Rutherford and Rodriguez to prove their self-defense claims. If either were to lose their bid at immunity, they could appeal to the 3rd District Court of Appeal and ultimately the Florida Supreme Court. It was not surprising that Hirsch was the first to weigh in on the new law. Since becoming a judge in 2010, he often ruled broader legal issues that sometimes upend conventional norms. Earlier this year, the judge ruled that Miami-Dade County's inmate detention policy, spurred by President Donald Trump's threat to withhold funding to violate the Constitution, which is technically considered to be Prince versus the United States, which has been used in other cases around the country for that. Earlier this year, the judge ruled that Miami-Dade County's inmate detention policy. Sorry about that. Last year, Hirsch also ruled that a new death penalty sentencing structure was unconstitutional, a decision that later proved prescient. The Florida Supreme Court ruled the same months later. In 2012, Hirsch ruled that prosecutors could not say a fingerprint found at a crime scene was a controversial match, a decision later overturned by an appeals court. When a Tampa federal judge ruled in 2011 that Florida's drug law was unconstitutional, Hirsch was the only state judge to file suit. He tossed out more than 24 cases, but Miami's appeals court later reverses Hirsch's decision. So this is more like viewpoints based on research and so forth. And what he talked about here, Article 1, Section 9, that would be the first thing I like to look at about doing the same trial twice. And I'm going to believe it's on here be under Ballotpedia. And it says here, due process, no person shall be deprived of liberty or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. So something that's interesting. So how I see with this whole preliminary hearings, yet, like if the defendant or the person who's being the accused have to prove that to the case, to me that's incriminating. So you have to see that, and of course they want to this pretrial release and detention and so forth. I'm not going to go too specific, but that right there, in my view, has some merit to an extent. And of course, he used that thing about the whole on the procedures, because based on the law, which we'll read it right here. I got it right here, the so-called new law, and it's like 2 pages long, and they went to subsection 4 of this 776.032. It was considered immunity from criminal prosecution and civil action justified abuse of force for threatened, and it's been altered right down here. It says subsection. This is section 4. It's altered in a criminal prosecution on once a prima facie claim of self-defense immunity from criminal prosecution has been raised by a defendant at a pretrial immunity hearing. The burden of proof by clearly and convincing evidence is on the parties seeking to overcome the immunity from the criminal prosecution provided in subsection 1. Of course, subsection 1 of that says here, a person who uses or threatens to use a force as permitted in statute 776.102, statute 776.103, or statute 776.3031. Sorry about that. I'm getting these hiccups. It's justified. Excuse me, I get a shot of water so I won't get the hiccups. As is immune from criminal prosecution and civil action for the use or threatened use of such force by the person or personal representative of heirs or the persons against whom the force was used or threatened, unless the person against whom force or use threatened is a law enforcement officer as defined in statute 943.10 subsection 14, who was acting in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law or the person using threatening use of force knew or reasonably should have known that the person was a law enforcement officer as using the subsection. The term criminal prosecution includes arresting, detaining in custody, or charging in the defense. So it's interesting about subsection 4 is more of judicial proceeding, which they said it violates Article 5, Section 3, if I'm correct. So I got it right here, under judiciary. And like it says right down here, subsection A, of Article 5, Section 2, subsection A, administration, practice, and procedure. The Supreme Court shall adopt rules for practice and procedure in all courts, including the time for seeking appellate review, the administrative supervision of all courts, the transfer to the courts having jurisdiction of any proceeding with the jurisdiction of another court has been improvidently invoked, and a requirement that no cause shall be dismissed because the proper remedy has been sought. The Supreme Court shall adopt rules to allow the court and the District Court of Appeal to submit questions relating to military law to the Federal Court of Appeals or for the armed forces for an advisory opinion. Rules of court may be repealed by general law enacted by 2/3 vote of the membership of each house of the legislature. So it's the House each and the Senate. Okay, so when you read this bill, okay, in the Senate, it was authored by the Senate, of course, and it's by Bradley, and it says here, because the judge made a claim that it infringes on it, because if you look at it, the Senate, it was in this particular bill, which is SB 128, once again, it was 23 yeas and 15 nays. That's an estimate 60.5%. And right here in the House, it was 74 yeas and 39 yeas, which is an estimate 65.5%. So it never hit the supermajority 66.7%. So in that area, he could say he has that cause in that area. So because based on what being addressed is on court proceedings, with this new law is considered unconstitutional under those areas. And he did made on the link from the Herald, he did make some statements on here on this particular case for the stand your ground. He did use that, and he even used certain areas on it is to, of course, the double jeopardy. Doing the same trial twice. In my view, okay, the prosecutor's got to prove their case. All right, if the person is gonna be they have to, as far as I know, they have to prove, not the other way around. That's how I see it. So it's always like a double-edged sword. And of course, the whole stand your ground has its pros and cons. It's run, but it's started by human beings. And of course, he did use some references, some past cases. Because remember, like the Castle Doctrine lets you stand your ground on that, and that's common law. It's been in the books for a long time, and it's in these pages. I'm like looking at the PDF format, which is on the Miami Herald's link, by the way. So don't worry, you can read this, and you probably get more information. Probably looking at this on your own than me interpreting it. And of course, it says here about about separation of powers, which Article 5, Section 2, which has been 2A, which has been I have addressed that already. So I'm going to add the Florida Constitution in there as well, so folks can look at it. The burden of proof, legislative changes at the issue, which is page 7 of 14 here. At issue here, purport alter 2 ways the burden of proof at a standing ground hearing. The burden of persuasion is shifted from the monvit, the criminal defendant claiming immunity, to the state. A quantum proof is altered from the mere preponderance of the evidence to clear and convincing evidence, because the question of the burden of proof are procedural rather than substantive. However, I necessarily find the demise. And of course, he used Article 2, Section 3 on here. Let's say it changes to be unconstitutional. See Florida Constitution, Article 2, Section 3, prohibiting one branch of government from exercising powers to another branch. All right, and let's just read that. Let's just check this out. Let's see what Article 2, Section 3 has to say. This is under legislative, of course. And it says here, Section 3, branch of the government, the powers of the state government shall be divided into legislative, executive, and judicial branches. No person belonging to one branch of government shall exercise any powers appertaining to either of the other branches unless expressly provided herein. Okay? So, so we'll just go on a little further. And he used a lot of cases here. And one thing, too, burden of proof, he uses that. And a lot of his mainly cases. But it says here, the issue is page 8. The issue bars illustrate at this point, as noted in Serpa and Dennis, the Supreme Court of the Florida explained that stand your ground law expressly grants defendants a substantive right not to be arrested, detained, or charged or prosecuted as a result of the use of legally justified force. And it says here, the legislative having thus engaged in the making of substantive law, thus the Supreme Court very properly engaged in the making of procedural law to afford a means to vindicate the substantive right. That procedural law directed a stand your ground monvent to proceed a pretrial motion and hearing, in which the hearing he was to shoulder the burden of proof by a preponderance of the evidence to show that she was entitled to the immunity and contemplated by the statute. And you can say that's a little bit related to Article 1, Section 14 of the Florida Constitution. So you can look that up. And I'm going to continue on here. And it says here, the immunity itself is substantive. Allocation of the burden of proof is procedural. The allocation has been placed in since at the least time. The Brethwick decision in mid-2015. He did talk about two-thirds majority override, which it hasn't really been used in this bill. So, like I said, it would under two-thirds majority. So technically, you can say respectfully, Judge Hirsch is right in those areas. All right, and he even used some quotes from the Federalist Papers, 46 and 47, which is very interesting as well. So you can really observe these areas pretty keen. All right, and but since here, Madison wrote, the legislative department is everywhere extending the sphere of its activities of drawing all powers into its impetuous vortex. That's James Madison, Federalist Papers 48. And see in Federalist 47, He quoted here, the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether heredity, self-appointed, or elective, may justly be pronounced the very definition of tyranny. So it has to have some balance. One can't supersede the other. For more modern expression of the same concern, see Colette Spano, Harry Potter, and the Separation of Powers. A law literature review of J.L. Tolkien's Harry Potter and the Order of the True. I don't know about that, so it's really pretty strange. And it says here about the opinion, the true opinion to the Supreme Court. This is page 12. All right. Amendments in Florida Evidence Code is a contractual conditional language, a final determination of the rejection of Dobert and the preservation of Frey will have to weigh natural case, but there is no such limitation here. The case at bar presents for rightly the issue rather than newly enacted subsection 4 of Florida Statute 776.032 is unconstitutional because of procedural, and that purports to reallocate the burden of quantum of proof. Wherever the merits or demerits of the Frey-Dobert analogy to this issue at bar, it is infragably settled the forms of practice and procedure to put in place by the Supreme Court of Florida. Whatever, formally reduced to a number rule of criminal procedure or not. Sorry about that. Just something popped up. Are procedural for purposes of the distinction be substantive and procedural lawmaking powers codified in Florida Constitution, Article 5, Section 2. All right, so here's why it says considered unconstitutional, and he used another reference here as well, that Phoenix Heford Law Journal, which there's a link for that. You can see it for yourself. So you try to use common law in here as well. So some folks, like I said, self-defense is righteous. I am not going to argue with that at all. But based on these Florida constitutions and all that, basically been written, the evidence got to have balance of power. So what I'm going to be doing here as well is I'm going to add Federalist Papers 48 and 47 by James Madison, which is from the website teachingamericanhistory.org. It's a good site, so everyone should check it out. But I'll give you those footnotes there as well, because people have to really know what is happening instead of hearing, the fine print and the face value instead of fine print. So, and what really gets me, because even some of the Dinkleberries, like from the New York Daily News and just other newspaper companies, trying to use Trayvon Martin case, which is very disturbing, regardless what side you're on. They try to use that. Oh, but Trayvon Martin, stand your ground. And the fact is this: George Zimmerman, never used that motion. So how's that guy do a stand your ground? You have someone on his back. It's considered classic self-defense. And I say that respectfully. No one really knows what actually happened based on the report. So what I'm going to be doing, even though it's a little bit, it hasn't really been updated, but Tempe Times, Florida Stand Your Ground, it tells you the pros and cons. It gives you every case. And it's not just always using a firearm. See, justifiable use of force in Florida is using anything necessary to protect yourself, your family, your property, and loved ones, etc., innocent bystanders. So folks, you better really look at this a lot more thorough. Instead of listening to the bobbleheads, these rhetoricians that want to talk out of their rear end to give you some doses to get you angry, which is a very good, method of public relations propaganda, written by what was done by Edward Bernays. They're trying to use that playbook over and over again. I know I said this in the past about the book Propaganda. You got to look it up, archive.org. I'm not going to add this to my footnote, but archive.org. When it comes to manifesting, check that out as well. It's a very good book. But a lot of the cases has its pros and cons. And let me just read the thing on and like I said, the whole thing was stand your ground. They think it's a get out of jail free card. It's nothing is guaranteed because there are times, like 26 cases here, they're found guilty by a jury. This is from, back then, charged in 35%, 59 cases. 23% were granted immunity from a judge. And, of course, not acquitted by, 16 cases here, 10%. So it's not 100% guaranteed. So when you hear these folks, oh, yeah, shoot first, ask questions later, do me a favor. Don't follow the hype. Always verify. That's one thing I like my listeners to know is to observe everything responsibly. And you know what? You won't regret it. So another thing I'm going to add here as well is the Chapter 776. All right. The latest edition, I would say, on Florida, on the whole justifiable use of force, because it needs to be addressed. And let's see if they have it here. Yeah, okay, good. So I got that in there as well. So you can really, folks, you really look at this more thoroughly instead of hearing the bobbleheads out there from either side of the paradigm. Because I want folks out there to read and learn. Because we've all been swindled one way or the other. So I'm going to use that in here as well with the Senate bill. You can look at this yourselves and the Federalist Papers. And, of course, the Stand Your Ground by the Tampa Bay Times, which is a real good job. I got to give them a lot of credit. And you'd be surprised some of the stories in here as well. And even there's many folks in the African-American community have benefited from this also. So, this is essential. And share with everyone you know. That'd be great, okay? All right, my friends. I know this is pretty short. So I'd like to thank everyone for listening. Plus, feel free to download and share us throughout your social media networks. If you have any questions, comments, or you're saying something that's interesting and may want to check out, whatever you do, please address your correspondences with decorum. You can hit me on Facebook, Twitter, Google+, Spreaker, iHeartRadio, Tumblr, YouTube, Freedoms Network, Scene.life, Minds.com, FutureClub.net, and Patreon.com/LokiLuck3 with 3 eyes all together. Okay? In addition, you can email me at LokiLuck3, which is number 3 altogether, at gmail.com, all for your encrypted types. LokiLuck03, which is both numbers altogether, at protonmail.com. All right, my friends, I'd love to hear your views on this and any other stuff, other episodes I have on there. It would be greatly appreciated, okay? Once again, thank you for your time. Plus, always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves, keep on spreading love, and may your guardian spirits be with you.